This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
But we're now on to statutory interpretation presumptions. We just looked at, in the last lecture, statutory rules of interpretation, or the rules of interpretation of statute. And we have the literal rule, words in a statute given their ordinary, everyday, literal meaning, unless to do so would be to lead to an absurdity, and that's the golden rule. Then we had the mischief rule about swimming sheep, and that was then followed by eostem generis, which was things of the same class in the road sign cases. Then we had expressio unius est exclusio ulterius. Do you remember that? The expression of one thing means the exclusion of the others. Anything that's not specifically mentioned or included within general words, cats, dogs, and other animals, then if you don't say and other animals, then it's only cats and dogs. Impari materia, noscitura sociis, the purposive rule, we had all of those, and not to be confused or not to be interpreted so that the interpretation is in conflict with Europe. And I repeat, I've no idea where we're going with that. I don't know whether the government has any idea where we're going with that. But also there are presumptions to the interpretation of statute. The courts will presume, and these are statutory principles, statutory presumptions. It is presumed, unless stated clearly otherwise. It is presumed, and you've got a list of presumptions here. The statute is not to alter existing common law, because common law has been developed over centuries. It's presumed that statute is not to change the common law unless it makes it perfectly clear. Statute is often brought about because it's putting in to formal statute the informality of common law that has been developed over hundreds of years. So it's enacting the common law. But the principle here is that the common law has been established. We don't now suddenly want to change it by statute, unless we make it perfectly clear that that's what we're doing. Where statute deprives a person of its property, there should not be any situation where simply by passing a law, your property can be confiscated from you, can be taken away from you. There are situations where you can get compulsory purchase orders, but that's because it's for the benefit of the greater good. It's the purchase of land which would otherwise cause a motorway to deviate, and so you buy the land and you compensate the person. But it's not being confiscated from that person, it's being compensated. You have to reach an agreeable figure for compensation, but that's the case. Statute doesn't operate retrospectively. You can't do something today. You can't do something today, and then in the year 2025, statute is passed which makes your action today, if you had done it in 2025, it would have been illegal, it would have been a crime. But you can't pass a law in 2025 and come knocking on your door and say, do you remember what you did 7 years ago? Do you remember that? Well, we're going to prosecute you now. It was legal at the time. How can you make it subsequently illegal? Well, you can't. So statute is not to operate retrospectively. Statute doesn't bind the Crown. Whoa. Of course it doesn't. Her Majesty's government, at the moment until, I'm sorry, Your Majesty, but until you die, Her Majesty's government, and then His Majesty's government, is not going to pass legislation which is binding on her, him. So legislation shall not bind the Crown, and it's only relatively recently that the Queen has had to start accounting for her income and to pay taxes. Who to? To HMRC. What do the letters HM stand for? Her Majesty. Oh yeah. So she's paying money into the public purse operated by Her Majesty's Revenue and Customs, for the benefit, ultimately, one assumes, of her. Statute is not to deprive a person of their liberty. You can't pass a law which then deprives you of the freedom of movement. Well, you can actually, can't you? Because if the person is guilty of a crime, then you're going to send them to prison, and that's depriving them of their freedom. Well, yeah, so you pass law to apply in a situation where people are committing crimes against society, wrongs against society. And that, of course, is right. But you can't simply pass a law that says anybody called Arnold is going to go to prison. The statute operates throughout the UK. And again, I'm sorry, but I have to say it. Statute will operate throughout the UK, or in our situation, England and Wales, for the purposes of F4 English, because Scotland, of course, has its own laws, and Northern Ireland has bits of its own law, particularly with reference to the law of property. So we're talking about England and Wales, and statute in the past will operate throughout England and Wales, so long as it's not in conflict with Europe. Unless perfectly clear, statute is not to create an offence of absolute liability. If you drive your car and there is not enough tread on the wheels, or any one wheel of your car, if it doesn't meet the minimum, is it 10 millimetres, over 75% of the surface of your car, then you're breaking the law and there's no defence. There is no defence. But what if no? Well, yeah, but there's no defence. So along goes our man who's driving without the required depth of tread over 75% of the wheel surface, and he goes to court and he says, I'm sorry, but, and the magistrate said, no, but, there's no defence. Yes, but no. So the magistrate said to him, listen, can you spell the word dog as in dogmatic? Yeah, he says, D-O-G. Do you take me for an idiot? We'll come to that later. Can you spell the word cat as in catastrophe? Yes, C-A-T. Okay. What about spelling the word sod in defence? He says, there is no sod in defence. That's right, that's what we're trying to tell you. So unless perfectly clear, statute is not to create an offence of absolute liability. And then we get some strange stories, don't we, about having to wear a crash helmet. But Sikhs, a Sikh in Birmingham, established and proved that wearing a turban was rather safer than wearing a crash helmet. The turban gave better protection. Now that then begs the question, doesn't it? If that's the case, why did they not change the law and make us all wear turbans instead of crash helmets? Because it's safer. The law got changed. What about breathalyzer? Is there a defence for being over the limit, over the alcohol limit? Yes, there is. There is. A doctor was called up and he was not on call, but there was a major train crash and all the doctors and the doctors on call and the doctors, reserve doctors and all the doctors were on, and there was another accident. Not an accident, a man had been arrested for suspected being over the limit. So they called the doctor and he was at a dinner party. He answered his mobile phone. He was at a dinner party. And they said, can you come in? We need someone to say, well, get one of the doctors on call. They're all out. They're all treating an emergency train crash. So he said, well, I've been drinking. Never mind that. We need you in here now. So he drove in. And he tested the man. And the second breathalyzer in the station showed that the man was not over the limit after all. But as he was leaving, one of the policemen said, excuse me, doctor, have you been drinking? And he said, well, I told you I have. And they tested him and he was over the limit. So then they took him to court, they prosecuted him, and he pleaded his defence and said, they demanded that I go in. And I told them I'd been drinking, and they said, never mind, come on in. And the magistrate said, case dismissed. There is a defence. There was the defence about the policeman who wasn't properly dressed. He had his uniform on, but he didn't have his helmet or his cap on when he arrested, when he stopped the driver and breathalyzed him. it wasn't in uniform. You have to be arrested or stopped by a policeman in uniform. Without his hat, without his helmet, he was not in uniform. So there are defences, few and far between, but they are there. Statute is not to conflict with existing statute, of course not. The Parliament houses do their utmost to avoid situations where we have conflicting statutes. And there's a presumption that if one statute exists, then the next one is not in conflict. And if there's an element of doubt, pass it back to the Parliament and say, sort this out. And that's what they do at the moment, where statute is in conflict with Europe, with conflict with European law. And if they can't reconcile the English statute with the European statute, they send it back to the Houses of Parliament and say, sort it out, will you? Get it sorted so it's now in conflict with you. So it's now no longer in conflict with Europe. How long that is going to last, time alone will tell. We move on to aids to interpretation. There are two types, intrinsic and extrinsic. Intrinsic is within the statute itself. Extrinsic is external assistance. And within intrinsic, we've got a title of the statute. It gives us a clue as to the objective of the statute. I've given you the example there, the ANZAC brackets Protection of Trade Use of Word Act of 1916. This is to protect the good name of the Australian and New Zealand Army Corps, who fought with great valour in the Battle of Gallipoli in 1916. And in order to prevent other people, businesses, from trading on the goodwill associated with these brave Antipodean soldiers, the government passed the ANZAC Restriction on Trade Use of Word Act of 1916. The preamble, introduction to the Act, saying the Act has been introduced in order to blah, 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 prevent the brutal and inhumane hunting of foxes. And so the preamble will tell you what the purpose of the legislation is to prevent the mischief associated with film and the intense fire that is created when film catches fire. It will tell you what the purposes of the Act are. The interpretation section within statute. The interpretation section within the Companies Act, which we'll come to later, obviously, a major part of the F4 syllabus. The Interpretation Act tells us the definition of some words. The definition of a director is any person that occupies the position of director, by whatever name called. Yeah, okay. Is that what we call in computers a loop? A director is a person occupying the position of director. Okay. A debenture includes debenture stock, debenture loans, and unsecured debentures. How can a debenture be defined as being a debenture? But the definition section within the legislation is there to help us. And the margin notes. If you ever look at a piece of statute, if you ever look at an Act of Parliament, and they're freely available in Her Majesty's stationery offices, if you look in the margin, in tiny, tiny subscript, there's an explanation of sections or a summary of what that section is about. So these are intrinsic aids. These are aids to interpretation which are available for judges when they're interpreting statute. Extrinsic are things from outside that the court can pull in to help them interpret statute. So extrinsic aids include the reports. They can read the minutes taken at the committee stage and the various subcommittees of Parliament, and the minutes would be taken, and the judges are freely able to read those. Hansard. Hansard is the daily verbatim, word for word record of everything that is said in Parliament. And judges, relatively recently, over the last 50 years or so, judges are now allowing themselves to read Hansard or to look at Hansard to see what the discussion was when this particular clause, which is causing us a problem, when this particular clause was being discussed. A dictionary, obviously, to get the literal rules sorted out, and books of authority. There's a book of, I think it's American birds, by a man called Audubon. And Audubon described birds, but he also drew them. And it is a book of authority. It is the book on American birds from the time. And he drew life-size drawings. Imagine doing a life-size drawing of an ostrich, but fortunately there were no ostriches in America. But he's got life-size drawings of turkeys, and the book is that big enough for him to put in these life-size drawings. Well, that was a book of authority. Where there is a tome that is recognized in the profession or in the business or in the field of agriculture or whatever, where there is a book which is recognized as being the definitive book, then the court will allow itself to look at that. And those are extrinsic aids. And then, of course, there's the Interpretation Act of 1987, which basically it says, where it says in statute he, then it shall include she, him shall include her, his shall include hers. And so for the male, read the female, for the singular, read the plural. So the Interpretation Act prevents us having to, and I do it myself, I'm guilty of it myself, of writing things like he and putting in front of it an S to equalize it, if you like. And why is it always he when there should be she? So that's the Interpretation Act resolves that and says for the masculine read the feminine, for the feminine read the masculine. And that's that bit. Delegated, this is a way in which we can save parliamentary time. We delegate legislation. And different ways of doing it. So the statutory instrument, legislation will be passed in road traffic legislation, will be passed in a skeletal form. It will just be the bones of the. So the wearing of seatbelts is compulsory unless exempted from time to time by statutory instrument and issued by the Minister of Transport. So the Minister of Transport now has the responsibility of filling out that clause, that section. So the wearing of seatbelts shall be worn unless exonerated, unless excluded. You're no longer by statutory instrument, and statutory instrument will be issued by the Minister of Transport. And to my knowledge, I believe I'm right in saying, that you are excluded from the requirement of wearing seatbelts if you are a short stop delivery driver, a postman who's driving his van stops, driving his van stops, or a milkman drive, clink, 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 back, clink, 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 and you're a short stop delivery driver. You don't have to put your seatbelt on and then take it off and put it on and take it off. That's one. Another situation is if you're reversing, and particularly applicable to half the population, women, because to turn around in your seat, which way am I going? To turn around in your seat and wear a seatbelt as well, apparently is uncomfortable, to say the least. And so if you're reversing and you're turning around, you can unclip your seatbelt so that you've got more freedom of movement. And another one, again, it applies to women, obviously, is if you're pregnant, because the wearing of a seatbelt across your lap, in the event of a crash, that seatbelt could press so much so into your abdomen that you could damage the unborn baby. You don't have to, these are you don't have to be a pregnant milk delivery person doing their round in reverse. These are three separate situations where you may be exonerated. And I have visions, I'm sure it can't apply. But if you're stopped by the police and you're female and you're not wearing a seatbelt, and you say to the police, well, I'm exonerated from this, I'm excluded from the requirement because I'm pregnant, and he looks down at your stomach, as he naturally would, and says, how far gone are you? And you say, well, about an hour and a half. I'm sure that you wouldn't be able to get away with that situation. But that's an illustration of responsible ministers issuing statutory instruments. And it saves government having to get into the detailed nitty-gritty of working out who to be excluded from the requirement of wearing seatbelts. Bylaws. Burnley is a town local to where I'm from. Burnley is a city, local to where I'm from, and they passed a bylaw that says you shall not be allowed to exercise your dog in a Burnley park, in a park in Burn Parkland. And the reason is because you take the dog off the lead, the dog runs around and crouches down and has a shit. And then people like me with children, or used to have, and they're all grown up now, thank heavens, we would go along to the playground in the park, and invariably my children would hunt out and find and stand or roll in these piles of dog shit all over the local park. And so Burnley has resolved this issue and said you can't exercise your dog in our parks. You have to go somewhere else. And people openly are flouting this as a bylaw in Burnley, and it applies to Burnley and its home bureau. It doesn't apply to next door. It doesn't apply to Halifax. It doesn't apply to Preston or Blackburn. It applies to Burnley. And Burnley dog owners are taking their dogs in and letting them be exercised all over the Burnley parks. And Burnley have taken them to court, and the magistrates have said you've got to stop doing it. And people who are adamant about this say, I'm not stopping. I've exercised my dog in this park ever since I've had a dog. I'm not stopping. So then they take it again, and they're taken then to Crown Court because they are in breach of a magistrate's order and they're in contempt of court, and they face prison just because they want to take their dog for a shit in a Burnley park. It's incredible. So bylaws passed by local authorities, delegated. Can you imagine 635 MPs discussing whether or not to allow dogs to defecate in Burnley parks? Can you imagine that? No. And so they delegate the legislation to the local authority. Rules of court made by the judges make their own rules. This is how things will proceed. This is how we want to see law being processed. So the judiciary will make their own rules, and those rules are delegated legislation. Professional regulations. I've said here the General Medical Council. What about the ACCA? The ACCA have their own rules, and they shall apply those rules. And if you cheat in any of your exams and you are discovered, out you go, and you will not be allowed to take those exams again. You will not be allowed. They make their own rules. They're depriving you of your freedom to take exams. Auditing Council, very rare, very, very rare. Auditing Council. Privy Councillors, the monarch is able to collect around her specified former politicians, typically, a former lecturer at financial training, which is now Kaplan, became leader of the Conservative Party, and then he was offered a position of a Privy Councillor to sit and advise the Queen on those matters that needed urgent attention. How often does that happen? Very, very rarely. It is an available example of delegated legislation accepted as that. Advantages and the importance, well, there you have them. There we are. Saves parliamentary time. Of course it does. Greater flexibility, because Burnley may stop their dogs, but Bury won't, and Blackburn won't, and Halifax might want to. So we have flexibility within the different localities. Allows general principles to be written into statute, where Parliament will pass a skeleton act, and along comes the minister to put the meat and the flesh on those bones. It allows variability, because if it is decided eventually that the Sikh in Birmingham was right and that turbans are safer than crash helmets, and then the Minister of Transport can say, right, we're all going to wear turbans now on our heads when riding motorbikes. So it gives us that flexibility and freedom to put flesh on as and when different ministers feel it appropriate. Allows very quick passing of statute, national emergency, declared war against Argentina when they invaded Falklands, boom, straight away, declared war, very, very quick. And prevents Parliament from being overwhelmed with an excessive workload. It saves parliamentary time, it saves the wheels of Parliament grinding to a halt because they've got just so much work to get through. And they can't get through it all. not when they have 13 weeks off during the summer for the summer break. How do you expect them possibly to get through all this work if they have to have this 13 weeks holiday? And so by delegating, we can save parliamentary time.